After weeks of procedural wrangling between the government and the opposition, MPs had the chance today to grill the head of Elections Canada, Marc Maron, and on his view on the government's proposed changes with the Fair Elections Act. Marc Maron had a lot of concerns, and I just want to show you some of what he had to say.
The response of Canadians in the face of the robocall affairs have been overwhelming. Canadians rightfully expect that such conduct, which threatens the very legitimacy of our democratic institution, be dealt with swiftly and effectively. Without the power to compel testimony, as exists in many provincial regimes, the Commissioner's ability to carry out this investigation will remain limited.
That's just one complaint Marc Maron's got with the Fair Elections Act, the ability to compel testimony, one of 20 amendments he would like to see made to the Fair Elections Act. Will the government heed his warnings over voter disenfranchisement? Will Elections Canada be able to warn voters about fraudulent robocalls if this bill goes through? Will the government give the Commissioner of Elections the power to compel testimony from possible voter fraud witnesses? Joining me now for some response to Marc Maron's testimony, the Minister of State for Democratic Reform, Pierre Poilievre. Good to see you, Minister.
Good to be with you.
Let's start with what he wants, and then we'll walk through a couple of his key concerns here. Why will you not give the Commissioner of the Elections the power to compel testimony? It's already allowed under the Competition Act. It's already allowed by several provinces. He says it's critical. Why won't they get that?
The Commissioner of Canada Elections already has the same investigative powers of a police force. Police forces that investigate the most heinous of crimes in the most complex circumstances with the most uncooperative witnesses do not have the power to force people to speak against their will. That being said, they do succeed in securing convictions for those very serious crimes. The Commissioner has all of the same powers as the police force. Beyond that, the Fair Elections Act will give him sharper teeth, a longer reach, and a freer hand. A longer reach and sharper teeth mean tough new offenses and increased penalties for existing
but hang on.
offenses.
Let me talk about this. I mean, you've been on it. We've talked about this a lot. Here's what he says about the power to compel. One, the Competitions Act, Section 11 under the Competition Act, they've got it. Several provinces, and I'll read what he says. The power to compel witnesses to provide information has been identified by the CEO and the Commissioner as critical operation tools to assist in effectively investigating elections offenses. So they need to get that in order to get quick answers to things like the robocalls investigation. Why don't you listen to him? And by the way, the caveat here, compelling witnesses would only come, quote, with a court order. So it's not like they can willy-nilly do it. They got to get a court order as a safeguard. What's the problem with that?
Again, he already has the same powers of a police force, and we have, much more serious crimes that could be investigated by a police officer for which this power does not exist. And yet, convictions are secured all the time in extremely complex circumstances with very uncooperative witnesses. So,
but you've seen the robocalls. No one's talking. I mean, he even said himself. He says people literally just ignore them. And if we want a free and fair election, if we want trust in it, he says, with a court order, this will help me investigate. He says it's critical. Why ignore the advice of the guy who runs the elections?
Well, he doesn't run the investigations. That job falls to the
elections,
Commissioner. It falls to the Commissioner, and our view is that giving him the same powers as a police force is reasonable.
Okay, so that there will be no amendment on that, just to be clear.
We have already made our position clear on that issue.
Okay. Let me take it to a second one. He also said changes around how Elections Canada is allowed to communicate to voters, Section 18, would mean he couldn't even put out a press release warning people about possible voter fraud, like the robocalls he said in Guelph. If Elections Canada can't warn people, he doesn't even think they can communicate to that. He believes that's muzzled. He believes there's no other democracy in the world that takes that power away. Who will warn people about that?
I would hope he would. There's nothing in the Fair Elections Act that would prevent him from doing that, but he has taken a different interpretation of our amendments to Section 18 than I do. That being said, as I've stated on this show about 3 weeks ago, that normally when there is some confusion by the head of an agency as to the meaning of words in a bill, the committee will just insert a for greater certainty clause to make it clear.
So will there be a change there?
Like I said, like I said 3 weeks ago on this show, I don't have a problem with the committee inserting a for greater certainty clause to make it clear that the amendments we're bringing forward have nothing to do with his ability to speak and communicate.
Okay, so we can look for an amendment there. Let's talk about vouching. This has been a big issue. This bill will no longer allow people without ID to be vouched for by another voter with ID at the polls. You pointed out there were 50,000 serious irregularities in the last election, but some of those irregularities included things like a nurse at a care home vouching for more than one patient, or a mother's vouching for her son, returning officer writing mother in the box instead of the person's actual name. Let me just show you what Mr. Maron said about the vouching today. Check this out.
What the Supreme Court is saying, you cannot equate an irregularity with an illegal vote. And that's what we have to be careful.
He's basically saying, if vouching is repealed, you risk disenfranchising thousands of Canadians. What's your response?
Well, first of all, he did make some factual errors on this point during his testimony today. He said, and I have his transcript here, that that these cases of irregularities, even irregularities, they're not irregularities that could compromise an election. Actually, his own report on page 10 said, and I quote, "The Supreme Court made it clear that such errors in other circumstances could contribute to a court overturning an election." I should also point to another part of that same report, page 5, quote, "Errors that involve a failure to properly administer these procedures are serious. The courts refer to such serious errors as irregularities which can result in votes being declared invalid." Right. So that doesn't sound like these innocent errors where somebody wrote mother instead of writing the mother's name. Furthermore, the stats on page 64 of that same report show that that the errors as he described in committee are not the ones that accounted for the largest number. There were over 45,000 cases where either the voucher or the voter were not identified at all in the records, and that's a serious area in contravention of the rules.
Yeah, but here's the question.
He's actually wrong when he says these are small mistakes.
Okay, but here's the problem that he's raising. How many people, how much voter fraud was there? I mean, how many cases of voter? We know about Conservative MP Mr. Butt allegation that someone used a voter information card to perpetrate fraud. He made it up, clearly. He said he saw it, he didn't see it. So outside of the one that he made up, give me how many examples of voter fraud? Because Mr. Mayrand's point is, we understand voter fraud's bad and we've got to crack down. But on the other hand, there's not, in an effort to crack down on voter fraud, of which there's not a lot of examples, frankly, you will disenfranchise thousands of voters. And he doesn't think that's a smart trade-off.
Well, I mean, right now, according to his own report, there are, on vouching alone, 50,735 irregularities. Those are defined as serious errors that a court could use to overturn an election result or invalidate somebody's vote. That is serious. That is not a small bureaucratic hiccup. Furthermore, the fact is that it's his responsibility to administer these vouching procedures, and his agency did a very poor job of it in the last election. 42% of the times when vouching was used, there is a serious irregularity, and those irregularities, as I said earlier, could lead to a vote being invalidated or a result overturned.
But hang in there. But can you point to one case of voter fraud? Just give me one. I mean, this is important because he's saying the steps you're taking to eliminate vouching, to eliminate the voter information card. I'll read what he said. The Neufeld report estimates approximately 120,000 active voters in the last election relied on vouching. We can expect that a significant proportion of them would not be able to vote under the new rules. So he's saying you can't point to a lot of cases of fraud, and by taking these what you call anti-fraud steps, you are essentially disenfranchising thousands of people of their right to vote. What do you say to that?
The irony is that it's his agency that is responsible for prosecuting fraud under the Canada Elections Act through the Commissioner, which is currently housed in his office. And if anybody was to prosecute it, it would be him. But he can't because in 45,000 cases, he doesn't even have the names of the voucher or the voter. Let me read further from that report because it's really actually very damning. Too frequently, the errors are so serious that the courts would judge them to be irregularities that violate the legal provisions that establish an elector's entitlement to vote. This happened in over 50,000 cases, Evan.
But let me read you. He also counters with this. I'll read you this. It's critical to understand, as recognized by the Supreme Court of Canada, that the vast majority of these were strictly record-keeping errors by poll workers documenting the vouching process, not fraud or even irregularities that could compromise an election. And he also says
he's wrong about that. That's a factual error.
He says there is no evidence tying these errors with ineligible electors being allowed to vote.
That's not what the court found, though. The court found exactly the opposite of what he claimed. Let me quote right from his report on page 5. You can pull it up. The courts refer to such serious errors as irregularities which can result in votes being declared invalid. That's right out of his words.
But
I can point to other wording here.
We're swapping here. Listen, his fundamental point here is the main, and I'll quote him, the main challenge to our electoral democracy, he says, is not voter fraud. It's voter participation. His problem is you're using a hammer and you're cracking down on voter fraud, but it ain't the problem.
Yeah.
And you're going to hurt voter participation. It's a suppression of votes. That's his allegation.
Well, again, he's wrong in the facts and wrong on his prescription. The courts did not say that these are just small paperwork errors. They said the Supreme Court, this is right from his report, his report accounted for the Supreme Court's words by saying this: the Supreme Court made it clear that such errors in other circumstances could contribute to a court overturning an election result. This is right out of his own material. I'm not asking. This is not my opinion.
But remember, I know you're reading it, Mr. Poilievre. But he said it could have resulted. But his distinction is important. But it didn't, because there's no cases.
But that's because in 50,000 cases there are irregularities, including 45,000 where he doesn't even have a record of the name of the voter or of the voucher.
But do you think it's wise to make a law based on what you suppose might have happened? Don't you think it might be better to wait for the evidence?
I'm actually citing evidence. This is
out of his
report.
Irregularities, but you have no evidence that it led to fraud. That's his point.
Listen, the reason that they are considered irregularities is because they have violated serious rules that protect the integrity of the vote. The courts have recognized that these violations could lead to votes being invalidated or election results being overturned. And let me make one final point here. It's important that everyone have the right to vote. But remember that your right to vote is actually canceled out when somebody fraudulently votes for the opposing candidate. If you honestly vote for candidate A and someone else fraudulently votes for candidate B, he has literally canceled out your vote, and that is just as serious an issue.
Again, the problem is you don't know it's happened.
Well, I've just given you the data.
But again, the interpretation of the data is important. These are cases that it could have resulted, but the question is, did those? He's always saying, be careful, because just because there's an error doesn't make the vote ineligible. I think that's a critical distinction when it comes to the exercising your franchise to vote.
And I think that the average Canadian, if you ask them, do you think that you should be required to bring some identification to show who you are and where you live when you cast your ballot? I think the average person would say that's pretty reasonable. There are 39
let's talk about
different.
That,
sure.
There's talk about using the so-called voter information cards, the VICs, as ID. The cards, your colleague Brad Budd, as I talked about, had to retract a statement about. Mr. Mayrand pointed out firstly that people can't just use these voter ID cards anymore. They have to have another piece of ID to vote, but also 300,000 Canadians moved during the last campaign. They may not have had time to change their driver's license. You're required to show a place where you live. They can call Elections Canada. They can go online to change their VIC address. Won't disallowing voter information cards as proof of residence also risk disenfranchising seniors, young people, people who move? Why take that away?
Well, there's also a very high error rate on the voter information cards. Those cards are based on the voter list, which in the last election had an error in 1 of 6 cases. Many people get more than one card, which allows them to vote more than once, or at a place in a location where they do not live. We even had a comedy show in Quebec which was able to demonstrate that 2 people were able to vote twice each because they both received 2 voter information cards. Elections Canada had to follow up with a compliance agreement, and that problem could be more vast because there are large numbers of errors on the list.
So you won't make an amendment on that. So that's out.
We think it's fair that there are 39 different forms of ID that people can use. You don't even have to use photo ID
But
in
only
Canada.
13 of those have, remember, only 13 of those 39 have your address, and you need the address.
And you know what? I think that when you
the
give
VIC
that many
has
options,
your address.
And the VIC often is inaccurate.
Okay, two more things. I want to show you what Maron said about campaign spending limits, the provisions in this bill on party fundraising calls. Anyone who's ever made a minimum $20 donation contribution to the party, check it out.
For anybody who has ever seen one, there is no practical way of distinguishing a fundraiser mail out from advertising. And it takes little imagination to understand that other partisan communication can be dressed up as fundraisers. Just as importantly, it will be difficult, if not impossible, to enforce in the absence of any obligation to report or even keep phone records of the person contacted.
You don't keep the phone record. He says essentially this is a big fat loophole that will allow advertising to be masked as fundraising. Would you change that? He says that exemption should not be included. What's your response?
I disagree with him. There's a difference between spending money to campaign and then the cost of raising that money in the very first place. Now, let me explain what the Fair Elections Act actually does in this regard. First of all, there's a purpose clause. That means the communication, either by phone or mail, has to be for the purpose of raising funds. Two, it must be targeted at someone who has already contributed at least $20 in the last 5 years.
But he's saying you could disguise it. He says he calls it a gray area.
And here's where he's wrong. You can, under the Fair Elections Act, we could not simply run a television advertisement and then call it a fundraising piece because we asked for money at the end. It would have to be uniquely targeted to people who had donated in the last 5 years, which is, by the way, an extremely small number of people. Secondly, the Fair Elections Act will require scripts for all mass calls to be kept so that they could be examined by an investigator.
But scripts, but not the numbers of who you call. And then you're forcing Elections Canada to have to go read every script of every call?
No, first of all, every call uses the same script for the call, so they're going to change for every one of the hundreds of calls that are made in a fundraising appeal. No, this is a very reasonable provision, we support it.
Okay, I got one more. The bingo cards. Okay, this is interesting. The bill provides that a copy of all statements of electors who have voted, these so-called bingo cards, should be given upon request after polling day to the candidate or his representative, her representative to the party. In other words, the parties will now get to know if you voted or not. So you vote, they keep it who voted, and now the parties get to keep the information. So now the parties will know if you voted or if you didn't vote. There are genuine privacy concerns he has about it. He says this provision should not be included because it expands the use of these cards from their original use, and it basically becomes a campaign document. Would you take that away because it infringes on the privacy of a citizen to know if they voted or not?
Well, I've got news for you, Evan. Parties already have that information. At every polling location in an election, candidates have representatives who stand there and strike off the list the names of every single person who comes up and votes, and parties have the records into perpetuity of who actually cast a ballot. So that already exists.
Yes, except, here's what he says. They can methodically be, now he said, collect and document all Canadians after the vote who have voted, and he said information on who has voted should not be shared with parties further than it already is. His concern is that it goes further.
Well, it's already shared. Like I said, right now, under the existing law, you have somebody called the scrutineer, as for your party, who stands at the voter registration table, and when people walk up and they say, "I'm Bob Smith," that scrutineer makes a note that Bob Smith showed up to vote. So that information is already available. I don't know what the big deal is.
Well, they're there, but they're not turned over right away, right? You have to collect it by yourself.
Well, it's even faster. It happens. It's instantaneous.
Okay, so tell me something. What reforms? I've heard that you might put reforms because you've got the Marc Maron saying this is going to disenfranchise voters, disempower him from speaking to Canadians. He thinks this is basically not solving the problem you set out to solve. The opposition says get out and consult with Canadians. One government should not change the fundamental act of voting, the election system. Or is the government afraid to go across Canada and have consultations on a very important bill? What is the problem with that?
I think we just had consultations today. I think we've demonstrated our willingness to hear witnesses who disagree with our point of view, because we're very prepared to defend our position. We are winning this debate, and we're going to continue to have it going forward.
But
the
Mr.
Fair Elections
Poilievre,
Act will be good for the country.
You and I both know that that was a committee that was 50 minutes of testimony with 4 minutes and 7 minutes. What about Canadians? What about the people who want to vote? Don't you want to hear from them?
The opposition can suggest anybody it wants to come testify.
Why not go across the country? I mean, it's clearly an important issue because there are millions of people that vote. This is a very serious changes that you're making. Why not just consult?
Yeah, listen, the NDP, which has made the suggestion, announced its opposition to the bill before it was even introduced. And so I can't take responsibility for their opposition, because it wouldn't have mattered what was in the bill. They would have opposed it no matter what. It's unfortunate that they've made a partisan issue out of it, but I'm determined to continue to work towards a better election law, and the Fair Elections Act will do that.
Have you lost trust with Mr. Maron?
I don't understand your question.
Do you not trust the Chief Electoral Officer's point of view?
The Chief Electoral Officer does not report to me, nor should he. He's an independent officer of Parliament, and it's not my role to render that judgment.
All right. The debate is going on. I always appreciate you coming on and talking about a very important bill. Minister of State for Democratic Reform, Pierre Poilievre, thanks as always.
Good to be with you.